Hello everyone. In this presentation, an attempt would be made to explain the scope of various clauses of Article 16 of the Constitution with the help of decided cases. Article 14 guarantees the general right of equality, and Articles 15 and 16 are instances of the same right in favor of citizens in some special circumstances. While Article 15 is more general and deals with all cases of discrimination which do not fall under Article 16, Article 16 is more specific, and the guarantee against discrimination here is confined only to matters relating to employment or appointment to any office under the state. Article 15 does not mention descent and residence as prohibited grounds of discrimination, but Article 16 does. Article 16 consisted of 5 clauses originally, 16.1 to 16.5, to which 3 more clauses, 16.4a, 16.4b, and 16.6 have been added by the Constitutional Amendment Acts. Clauses 1 and 2 of Article 16 lay down the general rule of equality of opportunity in respect of public employment, and clauses 3, 4, 4a, 4b, 5 and 6 are exceptions to this general rule of equality of opportunity. According to clause 1 of Article 16, there shall be equal opportunity for citizens in matters relating to employment or appointment to any office under the state. What is guaranteed by Article 16 is equality of opportunity, and it is open to the authority to lay down such other conditions of appointment as would be conducive to the maintenance of proper discipline and efficiency among government servants. The expression matters relating to employment or appointment must include all matters in relation to employment, both prior and subsequent to the employment, which are incidental to the employment and form part of the terms and conditions of such employment. The guarantee in clause 1 will cover initial appointments, promotions, termination of employment, and matters relating to salary, periodical increments, leave, gratuity, pension, age of superannuation, etc. The government has the rule-making power to regulate the service conditions of its employees, but these rules have to be just, fair and reasonable. The same fundamental principle of equality of opportunity should apply in all these matters between persons who are either seeking the same employment or have obtained the same employment. Principle of equal pay for equal work is also covered by equality of opportunity in Article 16.1. The goal of Articles 14 and 16 is limited to equality among comparables, and this implies that reasonable classification having nexus with the object to be achieved is permissible. Article 16.1 is confined to employment by the state and has reference to employment in service and not to contractors. A contract for supply of goods is not a contract of employment in the sense in which that word has been used in the article. Independent contractors cannot call themselves employees of the state and cannot claim the rights conferred under this clause. The requirement of reasonableness discussed under the new approach to equality under Article 14 has been applied to Article 16.1 also, and unreasonable actions in relation to service matters have been invalidated by courts. Now coming to clause 2, it lays down specific grounds on the basis of which citizens are not to be discriminated against each other in respect of any appointment or office under the state. The prohibited grounds of discrimination are religion, race, caste, sex, descent, place of birth, residence, or any of them. The words any employment or office under the state make it clear that Article 16.2 also applies only to public employment. There is no constitutional prohibition against private persons or bodies preferring men of one religion over the other in making appointments. The scope of Clause 1 of Article 16 is wider than the scope of Clause 2 because discrimination on grounds other than those mentioned in Clause 2 of Article 16 has to be weighed and judged in the light of the general principles laid down in Clause 1. Provision for appointment of son, daughter, or widow of a deceased employee on compassionate grounds is not violative of Clause 2 of Article 16, but its extension to near relatives is invalid under this provision. Sexual harassment at workplace has also been held as a violation of the right to gender equality in public employment guaranteed by Article 16(2) in Apparel Export Promotion Council versus A.K. Chopra. The state and its instrumentalities are empowered to govern the employment and conduct of the employees with service conditions. Thus, in Khurshid Ahmed Khan versus State of UP, the Supreme Court held that service condition imposing an obligation to follow monogamy or family planning norms is not violative of Article 16. Now, Clause 3 is an exception to Clause 2, which forbids discrimination on the ground of residence. There may be good reasons for reserving certain posts in a state for the residents only. Under Clause 3, the Parliament is empowered to regulate the extent to which it would be permissible for the state to depart from the law laid down in Clause 2. Here, it is the Parliament alone which can prescribe such conditions, and that too in regard to state and not to the union appointments. The word state in Clause 3 signifies the whole of the state and not parts of the state, and hence residential qualification can only be prescribed for the whole of the state. Clause 4 expressly provides for the reservation of appointments or posts in favor of any backward class of citizens which, in the opinion of the state, is not adequately represented in the services under the state. The power conferred on the state can only be exercised in favor of a backward class, and therefore whether a particular class of citizens is backward is an objective factor to be determined by the state. While the state has necessarily to ascertain whether a particular class of citizens is backward or not, having regard to acceptable criteria, it is not the final word on the question. State's determination is justiciable and may be challenged if it is based on irrelevant considerations. The condition precedent for the exercise of powers conferred by Clause 4 of Article 16 is that the states have to be satisfied that any backward class of citizens is not adequately represented in its services. This condition precedent may refer either to the numerical inadequacy of representation in the services or even to qualitative inadequacy of representation. The advancement of the socially or educationally backward classes requires not only that they should have adequate representation in the lower rung of the services, but also that they should aspire to secure adequate representation in selection posts in the services as well. Reservation under Article 16(4) may be made in exercise of executive power without any legislation support. In M.R. Balaji versus State of Mysore, the Supreme Court held that the caste of a group of persons cannot be sole or even predominant factor for ascertaining whether a particular class is backward or not. Poverty, occupation, place of habitation may all be relevant factors to be taken into consideration. The scope of Article 16(4) was considered by the Supreme Court in Devadasan versus Union of India, in which the constitutional validity of the carry forward rule framed by the government to regulate appointment of persons of backward classes in government services was involved. This rule provided that if sufficient number of candidates belonging to the scheduled castes and scheduled tribes were not available for appointment to the reserved quota, The vacancies that remain unfilled would be treated as unreserved and filled by the fresh available candidates, but corresponding number of posts would be reserved in the next year for scheduled castes and scheduled tribes in addition to their reserved quota of the next year. The result was to carry forward the unutilized balance, that is, unfilled vacancies in the second and third years at one time. In actual effect, 68% of the vacancies were reserved for SCs and STs. The Supreme Court, by a majority of 4 to 1, struck down the carry forward rule as unconstitutional on the ground that the power vested in the government under Article 16.4 being an exception to Article 16.1, it could not be exercised so as to deny reasonable equality of opportunity in matters of public employment for members of classes other than backward. The court held that each year of recruitment must be considered by itself, and the reservation for backward communities each year should not be excessive so as to create a monopoly or to interfere unduly with the legitimate claims of other communities. The reservation ought to be less than 50%, but how much less than half would depend upon prevailing circumstances in each case. In State of Kerala versus N.M. Thomas, the Supreme Court, by a majority of 5:2, overruled its decision in M.R. Balaji and held that Article 16.4 was not an exception to Article 16.1 but a facet of the doctrine of equality enshrined in Article 14, which permits reasonable classification, and the classification of employees belonging to scheduled castes and scheduled tribes from other classes of employees for allowing them an extended period of 2 years of exemption for passing tests for promotion was a just and reasonable classification having rational nexus to the object of providing equal opportunities for all citizens in matters relating to employment or appointment to the public office. The temporary relaxation of test qualification made in favor of SCs and STs was warranted in the services in view of their overall backwardness. In Akhil Bharatiya Soshit Karmachari Sangh versus Union of India, the Supreme Court, following Thomas' case, upheld the validity of the Railway Board circular under which reservations were made in selection posts for the scheduled caste and scheduled tribe candidates. The court held that under clause 1 of Article 16 itself, the state may classify groups or classes based on substantial differentia. The fundamental right to equality of opportunity has to be read as justifying classification of the categories of SCs and STs separately from rest of the community for the purpose of adequate representation in the services under the state. In Chakradhar Paswan versus State of Bihar, the court, however, held that single post in any cadre could not be reserved either at the initial stage or in filling up a future vacancy. In Indra Sahani versus Union of India, the scope and extent of clause 4 of Article 16 was examined by the Supreme Court. In this case, the constitutional validity of two office memoranda of central government, one reserving 27% of vacancies in civil posts and services under the Government of India to be filled by direct recruitment from socially and educationally backward classes, and the other reserving 10% vacancies additionally for other economically backward sections of the people who were not covered by any existing schemes of reservation was challenged. By a 6-3 majority, the court upheld the first memorandum but invalidated the additional 10% reservation by the second one. The court held that backward class of citizens in clause 4 of Article 16 can be identified on the basis of caste and not only on economic criterion, But caste alone cannot be the basis for consideration, and the creamy layer must be excluded from backward classes. Upholding the validity of a total of 49.5% reservation, the Supreme Court held that barring any extraordinary situations, reservations should not exceed 50%. The 50% limit does not include those members of socially and educationally backward classes who get selected on their own merit. They are entitled to get adjusted against the open category. But this limit applies only to reservations and not to exemptions, concessions, and relaxations. For the application of 50% rule, a year should be taken as the unit and not the entire strength of the cadre, service, or the unit as the case may be. So long as this limit is observed, carry forward rule is permissible. The court has clearly held that Clause 4 of Article 16 is not an exception to Clause 1 of Article 16 but an independent clause. It is rather the means of achieving the right to equality enshrined in the article. It is an emphatic reference to the affirmative action which the state may adopt to improve the conditions of the disadvantaged members of the backward class of citizens. The court further held that Clause 4 of Article 16 permits classification of backward classes into backward and more backward. The reservation under this clause cannot be made in promotions and is confined to initial appointments. The court also directed the central government, state governments, and union territories to appoint a permanent statutory body to examine complaints of wrong inclusion or non-inclusion of groups in the list of OBCs. In order to bypass the Supreme Court's ruling on the point of no reservation in promotions in government service, the Parliament enacted the Constitution's 77th Amendment Act 1995. The new clause 4A was added to Article 16, providing reservation in matters of promotion to any class or classes of posts in state services in favor of SCs and STs, which in the opinion of the state is not adequately represented in services under the state. By the Constitution 85th Amendment Act 2001, the words "in matters of promotion to any class" in Clause 4A was substituted by the words "in matters of promotion with consequential seniority to any class." The effect of this amendment is that the state may provide reservation in promotion in services of the state with consequential seniority. In PG Institute of Medical Education and Research versus Faculty Association, the Supreme Court held that there cannot be any reservation in a single post cadre, either directly or by device of rotation of roster points. Such total exclusion of general members of the public and cent% reservation for the backward classes is not permissible under Clause 1 of Article 16 as well as under Clause 4A of Article 16. In making reservations for the backward classes, the state cannot ignore the fundamental rights of the rest of the citizens. The Constitution 81st Amendment Act 2000 added a new Clause 4B after Clause 4A in Article 16, putting an end to the 50% ceiling on reservation for SCs and STs and OBCs in backlog vacancies which could not be filled in the previous year because of non-availability of eligible candidates. Under Clause 4B of Article 16, vacancies which could not be filled up in the previous years shall be treated as a separate class of vacancies and will be filled up in any succeeding years and shall not be considered together with the vacancies of the year or years, even if they go beyond the 50% limit. The Constitution 82nd Amendment Act 2000 added a proviso to Article 335, providing for relaxation in qualifying marks or standards of evaluation to the scheduled castes and the scheduled tribes for reservations in matters of promotion to any class or classes of service or posts in connection with the affairs of the union or a state. In M. Nagaraj versus Union of India, a 5-judge bench of the Supreme Court unanimously upheld 77th, 81st, 82nd and 85th Constitution Amendment Acts. The court held that Articles 16.4a and 16.4b, which are enabling provisions, flow from Article 16.4 and do not alter the basic structure of Article 16.4 and are valid. They retain the controlling factors, namely backwardness and inadequacy of representation, which enable the state to provide for reservation, keeping in mind the overall efficiency of the state administration under Article 335. These amendments are confined to SCs and STs and do not obliterate constitutional requirements, namely 50% ceiling limit, the concept of creamy layer, and the sub-classification of OBCs on the one hand and the SCs and STs on the other hand, with the concept of post-based roster with inbuilt concept of replacement. Clauses 4a and 4b of Article 16 are enabling provisions and the state is not bound to make reservation. But if it wishes to exercise discretion for making such provision, it has to collect quantifiable data showing the two grounds, backwardness and inadequacy of representation of that class in government services. When the state of Karnataka enacted the Karnataka Determination of Seniority of Government Servants promoted on the basis of reservation to the Posts in Civil Services of the State Act 2002, the same was questioned in B.K. Pavitra 1 versus Union of India. The Supreme Court declared sections 3 and 5 of the Act and rules 4 and 4a of the Karnataka Government Servants Seniority Rules, providing for consequential seniority against roster points, to be unconstitutional on the ground that there had been no exercise for determining inadequacy of representation, backwardness and overall efficiency by state of Karnataka, which is a must for exercising power under Article 16.4 as mandated by the decision in M. Nagaraj case. In the absence of exercise under Clause 4a of Article 16, it is the catch-up rule that fully applies. After the aforesaid judgment, the state of Karnataka enacted Karnataka Extension of Consequential Seniority to Government Servants promoted on the basis of reservation to the Posts in the Civil Services of the State Act 2018 after collecting the quantifiable data. The same was again questioned in B.K. Pavitra 2 versus Union of India. This time, the Supreme Court upheld the validity of the legislation and the methodology of the state and evolved two parameters of judicial review. One, the executive is better aware of the prevailing conditions, and two, in the context of reservation questions like adequacy of representation, it would be left to the subjective satisfaction of the state, as it is the state's responsibility to promote substantive equality under the Constitution through reservations. The court held that it was not for the court to hold that the report was invalid because the best methods were not used by the committee for collecting the data, and on the basis of the report, it was open to the legislature to hold that there was inadequacy of representation of SCs and STs in the services. In Jarnail Singh versus Lakshmi Narayan Gupta, the Supreme Court clarified the law pertaining to reservation in promotions and allied matters as follows. No yardstick can be laid down by the court to determine the adequacy of representation of SCs and STs in promotional posts for providing reservation. Before providing reservation promotions to a cadre, state has to collect quantifiable data regarding inadequacy of representation of SCs and STs, and the state has to assess this taking into account the relevant factors. For the purpose of collecting data and providing reservation in promotions, cadre and not the group must be the unit, and cadre for the purpose of a roster means a particular grade comprising the number of posts to be filled by a particular mode of recruitment as per rules. Now coming to clause 5 of article 16, it is the third exception to the general rule laid down in clauses 1 and 2 of article 16, which forbid discrimination in public employment on the ground of religion. Article 16.5 provides that a law which provides that the incumbent of an office in connection with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion or belonging to a particular denomination shall not be treated to be repugnant to this article. This provision is intended to safeguard the freedom to manage religious affairs guaranteed under Clause 2 of Article 26 so as to balance it with the principle of equality of opportunity in the matter of public employment under Clause 1 of Article 16. Coming to Clause 6 of Article 16, this is inserted by the Constitution 103rd Amendment Act 2019, which enables the state to make provision for reservation of appointments or posts in favor of any economically weaker sections of citizens other than the classes mentioned in Clause 4, in addition to the existing reservation and subject to a maximum of 10% of the posts in each category. Economically weaker sections for the purpose of this clause shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantages. The constitutional validity of this clause was challenged in Janhit Abhiyan versus Union of India. The Supreme Court observed that reservation is an instrument of affirmative action by the state so as to ensure an all-inclusive march towards the goals of an egalitarian society by counteracting inequalities. It is an instrument not only for the inclusion of socially and educationally backward classes to the mainstream of society, but also for the inclusion of any class or section so disadvantaged as to be answering the description of a weaker section. In this background, the court held that reservation structured singularly on economic criteria does not violate any essential features of the Constitution of India and does not cause any damage to the basic structure of the Constitution, and exclusion of classes covered by Clause 4 of Article 16 also does not destroy the basic structure of the Constitution. The court further observed that in the complex setup of formal equality, on the one hand, which departs discrimination altogether, and real and substantive equality on the other, which permits compensatory discrimination so as to upset the disadvantages, exclusion is as indispensable as the compensatory discrimination itself. Regarding 50% cap on reservations, the court held that Article 16.6, which enabled the state to make a reservation on new criterion, that is, economically weaker section, and excluded classes already getting the benefit of reservation under Article 16.4, thereby taking total reservation to 59.5%, is valid and does not violate the basic structure of the Constitution, and the ceiling limit of 50% for reservations applies only to reservations as envisaged by Article 16.4. Thus, Article 16 provides equality of opportunity for all citizens in matters of public employment and prohibits discrimination on the grounds of religion, race, caste, sex, descent, place of birth, residence, or any of them. And this is subject to clauses 3 to 6 of the article, which provide for reservations in favor of any backward class of citizens not adequately represented in the services under the state, and any economically weaker sections as may be notified by the state. Thank you.